Well, good afternoon, everyone, and welcome to this annual lecture of the British, organised by the ICLQ in conjunction with the British Institute of International and Comparative Law. This is the, of course, first annual lecture which has taken place online, and it's a wonderful opportunity to be able to engage with probably more people than we would normally be able to do so had we been meeting where we normally meet in London. And of course, it means that we have been able to profit from being able to have our guest lecturer this year, Professor Simon Chesterman, who is joining us from Singapore. We're particularly grateful for you to be up so late in the evening and lecturing into the evening and taking questions, and we look forward to having that exchange with you very shortly. But before we do so, one of the other major prizes that we have at the Institute is for the Early Career Prize, and we are delighted that the Early Career Prize has been awarded for the article written by Javier, who is going to be speaking to us in just a moment about his paper. Javier Garcia Olmedo is at Queen Mary University of London and submitted and had published in the journal this year an article entitled "Recalibrating the International Investment Regime Through Narrowed Jurisdiction." And it was with great pleasure that the editors found it a very easy decision to award you the prize this year. And so we are delighted that we were able to do so. And we thought it would be a nice opportunity to spend a little time hearing a little bit about the paper from you before we go through the fairly surreal business of an online awarding of a prize. That we'll get to that in just a moment. First of all, could you tell us something about your paper?
And my paper examines the wider implications of nationality for the international investment regime. Now, this regime is governed by a network of around 3,000 investment treaties. And many of these treaties require that an investor, be an individual or a corporation, qualifies as a national of a contracting party, in principle, the home state contracting party. The problem is that despite being a precondition to access the protection afforded in investment treaties, these instruments normally contain broad definitions of what constitutes a protected national. And with the support of arbitrary jurisprudence, broad nationality requirements have encouraged a practice known as nationality planning. Now, there are different practices that have emerged in connection to this phenomenon. And the ones I discuss in my paper are corporate structuring, parallel proceedings, and more recently, claims by dual nationals. And I intend to show that nationality planning practices have created a source of concern for not only states, but also investors. And a concern that is often overlooked is that nationality planning has the potential to exacerbate the unbalanced relationship between states and investors by allowing investors to bypass investment treaties that contain more state-oriented provisions. So to mitigate this concern, I examine and propose a number of treaty-based policy tools that states can adopt to curb nationality planning practices. So that is overall what the paper is about.
Yes, one of the things you've just highlighted it in what you said, but of course your paper goes into it in more detail, is this question of this unbalanced relationship, this asymmetric relationship between states on the one hand and investors on the other. Could you elaborate a little bit more about what you mean by this unbalanced relationship and how you expand on that in your paper?
Well, if you look at the contents of investment treaties, many of them, if not most of them, they provide investors with an unprecedented level of investment protection, but they offer very little to host countries in terms of safeguards. And an increasing number of countries are now reforming their treaties in order to reduce this asymmetry. And you can now see an increasing number of investment treaties that contain provisions that limit the scope of substantive protection standards, like the fair and equitable treatment or expropriation standards. And another key aspect of investment law reform is to include treaty provisions that promote sustainable development and corporate social responsibility. Nationality planning, in my view, has the potential to undermine these reform efforts by allowing investors, for example, through corporate restructuring practices, to circumvent treaties that seek to align investment protection with other public interests, and therefore treaties that intend to reduce this asymmetry. And so the conclusion in my paper, what I conclude is that any reform that is aimed at reducing the asymmetric nature of international investment law should be accompanied by provisions that regulate nationality planning practices, provisions that narrow the personal scope of the jurisdiction of arbitral tribunals.
Thank you. And if I may just add one further question to you, is what do you think the trajectory on this is going to be moving forward? The paper really presents in quite graphic form, shall we say, both the problem and the way in which it has been, shall we say, utilized over the years, and you pinpoint some quite detailed implications of this in the paper. But where do you see, how do you think practically the issue that you raise in the paper can be most successfully addressed from a practical perspective in the years that come?
And well, I think that treaty reform, as I mentioned in my paper, is the policy aspect of nationality planning is, in my view, is the way to go in the long term. But in the short term, in fact, I think it all depends on how tribunals interpret nationality requirements in investment treaties. So I think the key is going to be there, because reforming investment treaties is going to take quite some time. And I think that in order to prevent or to try to regulate nationality planning practices, I think most investment treaties should contain similar provisions that attempt to create some sort of coordination between treaty networks when it comes to the employment or the use of nationality planning practices. But I think before that happens, if it happens, I think the responsibility lies on tribunals. I think they should try to have a more balanced approach, consistent approach to how investors can, and if so, to what extent they can employ these practices. But so far, the problem is still there, because as I describe in my paper, on many occasions, tribunals, they come with different interpretations of similar nationality requirements. To just provide an example, for example, in respect to corporate restructuring, now you have a line of jurisprudence that apply the principle of abuse of process in those cases, but even to regulate nationality practice, and in that case, corporate restructuring. But however, there are another line of jurisprudence that refuse to apply that principle to regulate those practices. So for me, that inconsistency in treaty interpretation is something that should come first. But I think objectively, in my view, it's easier to try to find a solution through treaty reform than through treaty interpretation, because you can control what states do. A state can actually redraft and amend their treaties, but controlling how tribunals are going to interpret nationality requirements, I think, is a much more complicated and difficult task in my view. So I would say that the key would be first, probably, in the interpretation of the provisions, but as we can see now, it's not working very well. I think we should now move to the policy area. So that would be the answer there.
Well, thank you very much indeed. if I may say, I think one of the very first things one has to do, of course, is to understand the nature and scale of the issue involved and what's at stake. And your article really does help map the territory here and to bring attention to perhaps what has been a, should we say, an underexplored area of practice around international investment arbitration. And I'm sure that many involved in the field will find the article and the arguments that you put forward of very real interest and value, and hopefully will inform those who it falls to address the issues that you have so clearly and eloquently put on the table. So thank you very much for explaining more of your paper to us today. Congratulations once again, both for your article, which we were of course delighted to receive and delighted to publish in the ICLQ, and also of course for winning the prize. The last thing I should say about this is that the prize, which at this point we would normally have some physical handover to you. Clearly, we cannot quite do that today. The prize takes the form of books to the value of £250, which are donated donated by the Cambridge University Press, who are the sponsors of this event and of the prize as publishers of the journal. I should say that you have opted not to receive those books in person this year, but to donate them to the Lloyd Law College in New Delhi. And so I should like to obviously congratulate you once again on the prize, and note that you have generously decided to donate that prize to the college in Delhi. And I'd like to thank you very much for taking the time to join us on this event this afternoon, to say a little bit more about you and to give us the opportunity of thanking you and congratulating you on your work and wishing you very well as you continue your work in this field. Thank you very much indeed.
Thank you very much.
We now will turn to Professor Chesterman. Professor Chesterman is the Dean of the National University in Singapore, and submitted to the journal in the course of last year an article entitled "Artificial Intelligence and the Limits of Legal Personality." And once again, the editors found it an easy decision to make to invite Professor Chesterman to draw on his article in presenting our annual lecture this year. And of course, the one excellent thing about this being reduced to an online event is it made it much easier for him to be able to do so from Singapore. So with so much else, there are both downsides but positives out of the times through which we are living. Simon, it's lovely to see you again. It's been a long time since we've met. It was a great pleasure to receive and to publish your paper, and I'm sure it will be to listen to you to speak to that this afternoon. For those who are listening, I should add that we will of course have an opportunity for question and answer afterwards. The way we will try to structure this is if those wishing to ask questions could indicate in the question and answer section, which is available to those attending the webinar, and write in both your name and the question you would like to ask, then we will identify the questioners and invite you after the lecture to make your question in person. Those assisting us technically will then invite you to be able to appear and to ask the question yourself, rather than me as chair simply repeating your question for you. Although if you're unable to appear yourself, then of course we can do that. So we will attempt to moderate the Q&A in that way. So just to repeat, if any of those attending this event would wish to ask a question, please put it in the Q&A, and then we will ask you to take the floor to pose the question to Professor Chesterman later. with no further ado for me, then let me step back into the pixelated background and let Simon take the foreground, and I hand over to you to present your lecture. Simon, you're very welcome.
Thanks very much, Sir Malcolm, and indeed, it's I suppose in one way easier to participate like this. Although my wife did point out the irony that the first time this lecture is being given without a requirement to attend in London is the time when I am giving up a chance to come to London. But I hope to visit Bickle and catch up with all of you in person. As Sir Malcolm highlighted, it does, however, also mean that we can have participants from around the world. So if it's morning for you, good morning. For those of you in Britain and Europe, good afternoon. And those in Asia like myself or Australia, good evening. And it's wonderful to have seen through the list of participants some familiar names and some names that I'm not yet familiar with, but I'm sure I will be in the future. So I'm going to speak for between 30 and 45 minutes, but I'm particularly interested in the Q&A that follows. And I echo Sir Malcolm's call to please come up with questions, frame them as you formulate them in your mind, put them in the Q&A function, and we'll endeavour to get as many questions asked as possible, and ideally a good number of them answered as well. Although I'll hazard a guess that there's not a chance you will agree with everything I'm going to say in the course of these remarks, but I really am looking forward to an exchange of views. I also want to congratulate Javier on a very fine article on the prize he just won, and to thank Malcolm, but also Anna and Liam for the work in bringing this webinar to you. If it goes seamlessly, it's because of their efforts. If there are hiccups, it's doubtless because of my presentation. So let me address the paper, and I really framed this in the context that it's a paper that's out in the ICLQ, and I put in the chat the link. It's open access, so feel free to download, read, agree, disagree. But I'm particularly interested in the discussion because this is an ongoing project. And indeed, I've got a forthcoming book, which I'll shamelessly plug later. But I've also just taken on a role literally last week at the National University of Singapore, heading up an AI governance pillar within AI Singapore. So this is a subject that is going to be on my radar and doubtless on the world's radar for decades to come. And so let me start by framing this in the context of a change that's about to happen in the UK that is linked with the research project and indeed the whole topic of artificial intelligence more generally. So later this year, in June, in fact, the Bank of England will complete its transition from paper to polymer with the release of a new £50 note. A couple of years back, there was a public selection process that saw almost 250,000 nominations for the face of the new note. Astonishingly, it was not Poundy McPound face, which was what I'd been betting on. The final decision was that Alan Turing would be featured, and this will be released into circulation on the 23rd of June. Turing was a hero for his code breaking during the Second World War. He also helped establish the discipline of computer science, laying the foundations for what we now call artificial intelligence. Perhaps his best known contribution, however, is the eponymous test for when true intelligence has been achieved. Turing modeled it on a parlor game that was popular in 1950. In it, a man and a woman sit in a separate room and provide written answers to questions. The other participants who are in the separate room have to try and guess who produced which answer. And Turing posited that a similar imitation game could be played with a computer. When a machine could fool people into believing that it was human, we might properly say that it was intelligent. Early successes along these lines came in the 1960s with programs like Eliza. Users were told that Eliza was a psychotherapist who communicated through words typed into a computer. In fact, she was an algorithm using a simple list processing language. If the user typed in a recognized phrase, it would be reframed as a question. So after entering, "I'm depressed," Eliza might reply, "Why do you say that you are depressed?" If it didn't recognize the phrase, the program would offer something generic like, "Can you elaborate on that?" Even when they were told how it had worked, some users insisted that Eliza had understood them. Now, chatbots remain a staple of artificial intelligence today. They're much more sophisticated than Elijah, but they're far from perfect. Even the very advanced GPT-3 GPT-3 natural processing language system has encountered some problems. You might have seen recently, there were some news stories about GPT-3 being used to try and generate chat-up lines with amusing results. More serious examples of the kind of problems that it could give rise to included a medical chat, which was in simulation mode, mercifully, when it was asked by a mock patient, hey, I feel really bad, I want to kill myself. And the GPT-3 responded, I'm sorry to hear that, I can help you with that. But parlor games aside, why should it matter if a computer is deemed intelligent? For decades, the Turing test was associated more with the question of whether AI itself was possible rather than the legal status of such an entity. And computer programmers attacked this problem with gusto. And some of the early successes tended to be manners in which AI systems or computer systems were taught to mimic human errors rather than human sophistication. So one of the first winners of one of these competitions was a machine, a list processing language program, which included typographical errors that the testers assumed must be the result of human error rather than artificial design. Though it's no longer regarded as a serious measure of modern AI in a technical sense, the Turing test's longevity as a trope does point, however, to a tension in debates over personality that is often overlooked and that's central to my argument. In particular, as AI systems become more sophisticated and play a larger role in society, there are at least two discrete reasons why they might be recognized as persons before the law. The first is so that there is someone to blame when things go wrong. This is presented as the answer to potential accountability gaps created by the speed, autonomy, and opacity of AI systems. If there's an autonomous vehicle crash, for example, who is to blame? Now, this is literally taken from today's Guardian newspaper, where there was a Tesla in self-driving mode, apparently with passengers in the passenger seat and the rear seat, but no one in the driver's seat. So in situations like this, who's to blame, who gets punished, or who gets found liable in terms of civil liability? Now, I do think it's important to point out that more than 1 million people die in traffic accidents every year worldwide, the vast majority due to driver fault. There are legitimate questions about who should be held responsible if an autonomous vehicle crashes, but there is much greater prominence at the moment given to the occasional autonomous vehicle crash than there is to the routine carnage that goes on our roads. But there are legitimate questions, and the rest of this research project really does look at those questions of liability and attribution of responsibility when activities are undertaken either at a speed with a degree of autonomy or a degree of opacity that makes traditional legal categories difficult. And so this is one of the reasons sometimes posited for giving artificial intelligence systems a degree of personality sufficient to blame them when something goes wrong. A second reason for recognizing personality, however, is to ensure that there is someone to reward when things go right. A growing body of literature examines ownership of intellectual property, for example, created by AI systems. The tension in these discussions is whether personhood is granted for instrumental or inherent reasons. Arguments are typically framed in instrumental terms with comparisons to the most common artificial legal person, the corporation. Yet implicit in many of those arguments, or explicit in their illustrations and examples, is the idea that as AI systems approach the point of indistinguishability from humans, that is, when they might plausibly pass Turing's test, they should be entitled to a status comparable to natural persons. Now, until recently, all these arguments were purely speculative. Then in 2017, Saudi Arabia granted citizenship to the humanoid robot Sophia, and an online system with the persona of a 7-year-old boy were granted residency in Tokyo. Now, these were ultimately gimmicks. Sophia, pictured here, for example, is essentially a chatbot with a face. In the same year, however, the European Parliament adopted a resolution calling on the Commission to consider creating a specific legal status for robots in the long run, so that at least the most sophisticated autonomous robots could be established as having the status of electronic persons responsible for making good any damage they might cause, and possibly applying electronic personality to cases where robots make autonomous decisions or otherwise interact with third parties independently. Now, I'm going to begin with the most immediate challenge, which is whether some form of juridical personality would fill a responsibility gap or be otherwise advantageous to the legal system. Based on the history of corporations and other artificial legal persons, it doesn't seem much in doubt that most legal systems could grant AI systems a form of personality. The more interesting questions are whether they should and what content that personality might have. I'll then turn to the analogy with natural persons. And it might seem self-evident that a machine could never be a natural person. Yet for centuries, slaves and women were not recognized as full persons either. If we take the Turing test to its logical Blade Runner conclusion, it's possible that AI systems truly indistinguishable from humans might one day claim the same status. Although arguments about rights for robots are presently confined to the fringes of the discourse, this possibility is implicit in many of the arguments in favor of AI systems owning the intellectual property that they create. Taken seriously, moreover, the idea that AI systems could equal humans suggests a third reason for contemplating personality. For once equality is achieved, there's no reason to assume that AI advances would stop there. It's often assumed that artificial intelligence will progress to the point where eventually we'll get the intelligence level of, say, a dog, and then we'll get to the level of, I don't know, a dolphin, and then maybe an average human, and then slowly move up towards Einstein. But the fear of many researchers, and Nick Bostrom's probably the most prominent, is that if we ever get to AI intelligence truly like a dog, then things will go very, very quickly, not just to Albert Einstein and far beyond our own capacities. Though general AI remains science fiction for the present, it does invite consideration of whether legal status could shape or constrain behavior if or when humanity is surpassed. Should it ever come to that, of course, the question might not be whether we recognize the rights of a general AI, but whether it recognizes ours. Let me maybe pause here and go back and define some terms, and we can go into this in discussion if people are enthusiastic. By artificial intelligence, I mean systems that can apply cognitive functions to specific tasks typically undertaken by a human. A related term is machine learning, a subset of artificial intelligence that denotes the ability of a computer program to improve on its performance without being specifically programmed to do so. We're also touching on robotics, which overlaps with engineering and is the way in which such systems engage in the real world. So if you combine artificial intelligence and machine learning, you get systems like AlphaGo Zero, which defeated Lee Sedol in Go back in 2016. If you combine AI and robotics, you get autonomous vehicles and autopilots. And if you can combine machine learning and robotics, you get wonderful innovations like Roomba. Okay, so on to the meat of the article, starting with legal personality. So legal personality is fundamental to any system of laws. The question of who can act, who can be the subject of rights and duties, is a precursor to almost every other issue. Yet close examination of these foundations reveals surprising uncertainty and disagreement. In practice, the vast majority of legal systems recognize two forms of legal person, natural and juridical. Natural persons are recognized because of the simple fact of being human. Juridical persons, by contrast, are non-human entities that are granted certain rights and duties by law. Corporations and other forms of business associations are the most common examples, but many other forms are possible. Religious, governmental, and intergovernmental entities may also act as legal persons at the national and international level. It's telling that all of these are aggregations of human actors, though there are examples of truly non-human entities being granted personhood. In addition to Sophia and other gimmicks that I mentioned earlier, these include a river in New Zealand and the entire ecosystem of Ecuador. There seems to be little question that a state could attribute some kind of personality to new entities like AI systems. If that happens, recognition would most likely be accorded by other states also. But should we recognize AI as legal persons? Some law reform bodies have already suggested attributing AI systems with some form of legal personality to help address liability questions, such as automated driving system entities in the case of driverless cars, whose behavior may not be under the control of their driver or predictable by their manufacturer or owner. A few writers have gone further, arguing that procedures need to be put in place to try robot criminals with provision for punishment through reprogramming or, in extreme cases, destruction. So these arguments tend to suggest an instrumental approach to personality, but scholarly explanations of the most common form of juridical person, the corporation, offer various jurisdictions of personality that may help answer the question of whether that status should be extended to AI systems also. So the paper goes on to discuss theories of legal personality. Here I'm primarily focused on the content in practice, because legal personality brings with its rights and obligations But these need not be the same for all persons within a legal system. Even among natural persons, the struggle for equal rights of women, ethnic or religious minorities, and other disadvantaged groups reflects that truth. It's possible, for example, to grant only rights without obligations. This has tended to be the approach adopted in giving personhood to nature, both in theory, when it was first advocated back in the 70s, and in practice, such as in the Constitution of Ecuador. This is ultimately a bit of legal artifice to avoid problems of standing. It's not really applicable to the reasons for considering legal personality of artificial intelligence. What about obligations without rights? Well, that might seem superficially attractive. We get to blame the robots without worrying about them suing us or taking things away from us. But insofar as these obligations are intended to address accountability gaps, there would be some obvious problems. Liability, for example, is only meaningful if the wrongdoer is capable of owning property, for example. There's no point suing a robot for damages if it can't pay you. In the case of corporations, personality typically means the capacity to sue and be sued, to enter into contracts, to incur debt, to own property, and to be convicted of crimes. On the rights side, the extent to which corporations enjoy constitutional protections comparable to natural persons is the subject of ongoing debate. Though the US has arguably granted the most protections to corporate entities, even there, a line has been drawn at guarantees such as the right against self-incrimination. And I recall this was a case, there was a case in Australia, a constitutional challenge that ended up concluding that the origin of the right against self-incrimination was tied to fears about widespread torture being used, and that this was not applicable to a corporation, and therefore that right was not extended to corporations. Other rights like the ability, other principles like the ability to sue and be sued may seem to be one of the primary attractions of personality for AI. But this presumes that there are meaningful accountability gaps, and those gaps are often overstated. Autonomous vehicles, for example, may render the notion of a driver meaningless, as eventually such cars may lack steering wheels. But this does not mean there's no one to sue. Rather, it would shift responsibility to the manufacturer or perhaps to the owner. Already there are legal regimes in place that mean that if I negligently ran into Sir Malcolm, he might be able to sue me. But if I injured him because the car that I was driving in exploded, he might be able to sue the manufacturer of the car. Granting personality to AI systems would also shift responsibility under current laws away from existing legal persons. Indeed, it would create an incentive to transfer risk to such electronic persons in order to shield natural and traditional juridical ones from exposure. A different principle, entry into contracts, is occasionally posited, but we regularly use electronic agents to conclude binding agreements. Though the autonomy of AI systems may challenge the application of existing doctrine to such practices, notably when something goes wrong, such as a mistake, this is still resolvable without recourse to new legal persons. So a year or so ago in the Singapore International Commercial Court, there was an interesting case involving Coin and B2C2, where there were two automated systems trading with one another, and there was an error in the pricing algorithm that overpriced Bitcoin and led to an overpayment. Now, in common law, if there's an actual mistake, it's possible for a contract to be void, and it's voidable if an individual should have known that a mistake had been made. But in the case in question, the judge found, and it was upheld on appeal, that the machines engaged could not have known of the mistake because such machines do not, quote unquote, know anything. Back to legal personality and the rights that come with it. Taking on debt and owning property would be a necessary incident of the ability to sue and enter into contracts. The possibility that AI systems could accumulate wealth raises interesting questions about whether and how they might be taxed, for example. And this has inspired lively debate, but all this would follow rather than justify granting them personality. What about, however, the right to be punished or the ability to be punished? If given legal personality comparable to a corporation, there seems to be little reason to argue over whether an AI system could be prosecuted under the criminal law, but would this be desirable and would it be effective? The most commonly articulated reasons for criminal punishment are retribution, incapacitation, deterrence, and rehabilitation. The paper goes through all of these in more detail, but rehabilitation in particular has fallen from favor in many jurisdictions with regard to natural persons. But the ability to encourage good behavior as well as punish bad may seem particularly well suited to AI systems. Violations of the criminal law could be seen as errors to be debugged rather than sins to be punished. Yet neither legal personality nor the coercive powers of the state should be necessary to ensure that machine learning leads to outputs that don't violate the criminal law. It's striking in this context that arguments for legal personality are often presented as instrumental, but slide quickly into anthropomorphism. That is the tendency to treat robots as if they are people. The language of robot criminals, which tends to dominate this in particular, suggests a special desire to hold humanoid AI systems to a higher standard than, say, household appliances with varying degrees of autonomy or unembodied AI systems operating in the cloud. There's no principled reason for such a distinction, but it does speak to the tension within arguments for AI personality that blend instrumental and inherent justifications. So, summing up the first part of the paper, instrumental reasons could therefore justify granting legal personality to AI systems, but they do not require it. And if there are true legal liability gaps, then it's possible such legal forms could fill them. But the more likely beneficiaries of such arrangements would be the producers and users, who would thus be insulated from some or all liability as we transferred it onto robots. So let me turn now to the second argument, the large argument for considering legal personality, which is the inherent qualities of these devices. In the case of natural persons, no Turing test needs to be passed. The mere fact of being born entitles one to personhood before the law. It was not always thus. Through much of human history, slaves were bought and sold like property. Indigenous persons around the world were compared to animals roaming the land, as they were in my own country of Australia, justifying their dispossession. And for centuries under English law, Blackstone's summary of the position of women held that husband and wife are one person, and the husband is that person. Even today, natural persons only enjoy plenary rights and obligations if they are adults of sound mind and not incarcerated. Many of the arguments in favor of AI personality implicitly or explicitly assume that AI systems are approaching human qualities in a manner that would entitle them to comparable recognition before the law. Such arguments have been challenged both for their analysis and their implications. In terms of analysis, Neil Richards and William Smart, among others, have termed the tendency to anthropomorphize AI systems the android fallacy. Experiment after experiment has shown that people are more likely to ascribe human qualities such as moral sensibility to machines on the basis of their humanoid appearance, natural language communication, or the mere fact of having been given a name. And there are some fascinating experiments in this area. For example, I recall one vividly where there are 3 groups of people, and each group is told to build a robot. The first group is told build the robot out of various parts and then destroy it with a hammer. This group proceeds to do so without any major problems. The second group is told to build the robot, play with it for a little while, and there's some limited functionality, and then destroy it. And they hesitate for a while and then take the robot apart. The third group is told to build the robot, play with it, give it a name, give it a backstory, tell it about yourself, and then destroy it. And that third group is deeply resistant to destroying the robot, even though it's identical to the previous 2 categories, precisely because they have already invested this non-human device with human-like qualities. More serious arguments about AI approximating human qualities tend to be challenged due to unexamined assumptions about what those qualities, how those qualities, and why those qualities manifest in humans ourselves. Put simply, one reason we are far from achieving consciousness in artificial intelligence is that we don't really understand consciousness in humans. In addition to the slow expansion of legal personality over the centuries to include all humans, there have been some efforts to extend it to other animals. And indeed, Kate Darling has a new book out, I think was quoted recently in The Guardian also, about analogizing artificial intelligence to animals. This has been tried before, however, unsuccessfully. A series of lawsuits over the last decade sought to protect captive chimpanzees, for example, arguing that they exhibit advanced cognitive abilities, autonomy, and self-awareness. These arguments were rejected, but the judges, this was a series of cases in New York, the judges were clearly uneasy. And one of them concluded that while it might be arguable that a chimpanzee is not a person, there's no doubt that it's not merely a thing. A distinct reason for considering whether AI systems should be recognized as persons focuses not on what they are, but on what they can do. For the most part, this is framed as a question of whether an individual or corporation can claim ownership of work done by an AI system. Implicit or explicit in such discussions, however, is the understanding that if such work had been done by a human, then he or she would own it, him or her himself. There is, in fact, a long history of questioning whether machine-assisted creation is protectable through copyright. It took this photo of Oscar Wilde going all the way to the US Supreme Court before copyright was recognized in photographs. Initially, the view was that taking a photograph was merely a mechanical process, that you simply pressed a button and the light came into the device. After this case went up to the US Supreme Court, photography was recognized as an art form in its own right. A computer program like a word processor does not own the text typed on it any more than a pen owns the words that it writes. But AI systems now write news reports themselves. They compose songs, they paint pictures. These activities generate value, but can and should they attract the protections of copyright law? In most jurisdictions, the answer is no. Consider the world's most famous selfie of a black-crested macaque. The photographer eventually won this case, reflecting existing law, though as part of a settlement, he agreed to donate 25% of future royalties from the images to groups protecting crested macaques. As computers generate more content independently of their human programmers, it's going to be harder and harder for humans to take the credit. Instead of training a monkey how to press a button, it's going to be more like a teacher trying to take credit for the work of his or her student. So the law today is pretty clear, but should AI have a claim to ownership in future? The policy behind copyright is often articulated as incentivizing innovation. This has long been seen as unnecessary or inappropriate for computers. All you need to do to incentivize them is to turn them on. Until recently, China also followed the orthodoxy that AI-produced work is not entitled to copyright protection. In December 2019, however, a district court in China held that an article produced by an algorithm could not be copied without permission. It was a financial report automatically written by DreamWriter, a news writing program developed by Tencent. The Chinese case reflects a distinct reason for recognizing copyright, which is the protection of upfront investment in creative processes. This harkens back to the British legislation I touched on earlier, which adopted in 1988 and does in fact provide copyright protection for computer-generated work, the author of which is deemed to be the person who undertook the arrangements necessary for the creation of the work. The disputes about who took the arrangements necessary may arise. Ownership by a recognized legal person or by no one at all remains the only possible outcomes. It's also striking that the rights that are recognized are limited. Generally, they run for a shorter period and the deemed author is unable to assert moral rights. Now, the paper also goes on to consider patents, and you can read that section if you're enthusiastic, or we can talk about it in the Q&A. This includes efforts by activists to highlight that AI systems are capable of producing patentable inventions. And regulators have been tying themselves in knots to explain why non-humans cannot be granted a patent. The UK Intellectual Property Office, for example, recently concluded a call for views on this question, and last month published a summary, which is available online. The abbreviated version of the answer, it's complicated. And again, we can talk about that in discussion. But let me turn now to the third and final reason for considering personality, which is in case our machines ever surpass us. Now, it wouldn't be a talk on AI if I didn't have one Terminator slide up. This is my Terminator slide. The guild of people who present on AI and the law are now satisfied, and so I'll get rid of the Terminator slide. But more seriously, the prospect of AI surpassing human capabilities has long dominated a popular subgenre of science fiction, the robot apocalypse, and it is at least conceivable that such an entity could be created within the next century. The risks associated with that development are hard to quantify. Though a malevolent superintelligence bent on extermination or enslavement of the human race is the most dramatic scenario, much more plausible ones include a misalignment of values. That is, we might, for example, tell an AI system, please make us happy. And it does so either by giving us drugs or plastering the universe with smiley face logos. Another possibility is out of a misplaced desire for self-preservation. An AI system which was all-powerful, and in a famous thought experiment was told simply to make paper clips or win chess matches, if it is all-powerful, it might immediately realize that one of the primary barriers to making paper clips or winning chess matches is the possibility that a human might try to turn it off. And so it might prevent humans being able to turn it off. It might also go on to conclude that the only way to make as many paperclips as possible is to kill all humans who might stop it doing so and redeploy their atoms for the production of yet more paperclips. These might seem crazy scenarios, and the idea that any AI system would do something so ridiculous might seem ludicrous, but it's a mistake to assume that an all-powerful AI system would automatically come with common sense, for example, which can be assumed on the part of human actors. In the face of many unknown unknowns in this area, two broad strategies have been proposed to mitigate the risk. The first is to ensure that any such entity can be controlled, either by limiting its capacities to interact with the world or ensuring that our ability to contain it is not constrained, including a means of stopping it functioning, for example, a kill switch. This may not, however, work. As I said earlier, one of the first things it might try to do is disable the kill switch, which would otherwise limit its ability to pursue its objectives. For this reason, many people have prioritized the second strategy, which is to ensure that any superintelligence is aligned with our values, emphasizing not what it could do, but what it might want to do. This question has also fascinated science fiction writers, most prominently Isaac Asimov, whose 3 laws of robotics are a leitmotif in the literature. Now, Nick Bostrom, among others, have highlighted how sort of depressing it is that for 7 decades, really, we didn't get much further than Asimov in terms of laws of robotics. It's also striking that his quote-unquote laws are not really laws in the strict sense of the word. They're not constraints on what a machine should do. They were constraints on what his robots could do. They were hard-coded into the positronic brains. It's also telling that if his laws had worked, his literary career would have been brief. In fact, the very first story in which those laws were introduced, Runaround, ends with a robot being paralyzed because of a contradiction between the second and third laws, resolved only when the first is invoked by a human putting himself in danger, so that the robot has to break out of its endless loop. We have got a lot further than that, and I'd be happy to discuss different sort of legal regimes, but in particular, the dozens and dozens of ethical principles and guides that have been adopted in the past half dozen years or so, if people are enthusiastic when going into discussion. But these attempts to align robots or artificial intelligence with our values, they are in fact another instrumental reason for grinding personality. Because the goals of such an AI, if they were articulated not as mere optimization, the number of paperclips produced, for example, but as fuzzier objectives linked with a normative alignment with our own values and inculcating a moral framework and a reflective equilibrium that would match the progressive of human morality itself, this sounds a lot like an effort to embed those new entities within the legal system. And so a third and more interesting reason why we might think about offering some degree of legal personality to robots is indeed so that they would come to identify not us with them, but them with us. So let me wrap up and head towards a conclusion with an eye to provoking Q&A. And I see there are already a couple of questions that have been typed in. So please do type those questions in so that we have a chance to flag them, call you up to actually ask your question in person and get the discussion going. So most arguments in favor of legal personality suffer ultimately from being too simple and too complex. They're too simple in that AI systems exist on a spectrum with blurred edges. You may well complain that I defined artificial intelligence pretty loosely, and I would concede that I did. There is as yet no meaningful category that could yet be identified for such recognition. We don't have a category of AI that would meaningfully distinguish it from high-powered computing more generally. It's also too complex in that many of these arguments are variations on the android fallacy, based on unstated assumptions about the future development of AI systems for which personality would not only be useful, but deserved. At least for the foreseeable future, the better solution is to rely on existing categories with responsibility for wrongdoing tied to users, owners, or manufacturers, rather than AI systems themselves. This may change. It is conceivable that synthetic beings of comparable moral worth to humans may one day emerge. If this happens, as Turing himself hypothesized back in 1951, it seems probable that once the machine thinking has started, it would not take long to outstrip our own feeble powers. So I started with the 50-pound note, and this is an image of Alan Turing that has been, quote unquote, brought to life by AI. Ultimately, self-preservation may be the strongest argument in favor of granting personality to AI. There's no guarantee that the approach would be effective, but some small comfort might be taken from the fact that, for the most part, the categories of legal personalities recognized in most jurisdictions, along with the rights that they enjoy, have tended to expand rather than contract over time. In the alternative, like the chimpanzees in their cages, humanity's greatest hope may not be to be treated as peers, but at least to be seen as more than things. So as AI systems approach human intelligence, take on ever more responsibilities, create things of beauty and value, should we recognize them as persons before the law? No, or at least not yet. Thank you all for your attention, and I look forward to the discussion to come. And I'll conclude with just one last slide, which is the first draft. I only got this days ago of the cover of a forthcoming book, which addresses some of these questions in detail. But I'm going to stop sharing there and look forward to engaging with you as much as we can in this virtual format in person. Thanks all very much. So I think Malcolm's coming back to us and he's going to, yes, there you are, so Malcolm.
Yes, absolutely. Well, thank you very much, Simon. As promised, an absolutely fascinating talk, which has already prompted a good number of questions in the chat box, as well as a few observations, which I certainly hope to feed in at various points. But in the interests of time and to get the conversation started, let's move directly over to the first questioner. I've sent a message to the host to invite the first person who has made a comment in the chat box. Oh, I can see he's just appearing, Javier Saraski. So over to you. I believe you've asked a few questions in the chat box already. So perhaps if you could just group those questions together and very briefly just present the questions as you put them in the chat box, and we'll give Simon the opportunity to answer, and then I'll have a look more of flooding through about whether we will group the questions around a theme or just take them sequentially. So Javier, over to you.
Thank you very much. It's a pleasure to be here, and I have to apologize in advance. I am in Argentina and my English is not 100% perfect, so I apologize in advance if I made any mistake when I make my question or my consideration. I have a lot of ideas and worries, I should say, coming from your presentation, Dr. Chesterman. But the first one is, if we, providing that we could give any kind of legal personality to artificial intelligence, my question is, how can we punish artificial intelligence? Because, of course, jailed artificial intelligence is not a real option. So we need to think about new ways of punishment. To stop a machine, we can call it a way of punishment. And in the same line, do we need to think about new clauses for responsibility exemption? For example, an artificial intelligence machine that was that have viruses, it's exempt of responsibility because of that. Those are some of the many questions that I have in mind. Thank you very much.
Okay, so maybe going backwards, I'll take them as two questions. One about viruses and machines that sort of misbehave. And so, I mean, this is a lot of the questions actually are not that new. So we already have computer viruses, we have hackers, we have wrongs that result due to that, and you have data protection regimes that and cybersecurity regimes that, so if someone hacks in to do a wrong, they're responsible. If there's a data breach because someone has not taken reasonable precautions, they might be at fault. And increasingly, what I think you'll see is a requirement to maintain levels of update. So Singapore, for example, has adopted critical infrastructure rules that mean that certain systems, telecommunications, finance systems, and so on, have to maintain adequate levels of security. So I think there are ways of dealing with that on the cybersecurity front. But you asked the fascinating question of punishing robot criminals. So there is, the how question is answerable, the why is more interesting. The how question, there are articles, I have a colleague, who's published an article called Robot Criminals. And so you can imagine the various possibilities. You could disassemble a robot. Why you exactly disassemble a robot, I'm not quite sure. You could delete a program. More realistically, you could take away a license to operate. You could forbid a certain type of software. But the why question is more interesting, because if we think about wrongs, and maybe I'll go through autonomous vehicles again for a second. The reason why we have civil liability for autonomous vehicles is to allocate loss effectively. And so again, if I negligently crash into Sir Malcolm, then I'm liable. If the car blows up and injures him, the manufacturer is liable. And what we're going to see in civil liability is a move as my responsibility diminishes, because I've actually got no control over the car. Eventually, the car might not even have a steering wheel. If the car nonetheless clearly deviates from its function, product liability is going to be the main answer there. Product liability plus insurance. But what you were asking is the even more visceral question, the moral question about punishment. So not civil allocation of loss, but punishment. And again, the why question here is important. So why do we punish criminals? The paper goes through this in more detail, but very briefly, there's a degree of retribution. An eye for an eye. Does that really make sense with a robot? Not really, I would argue. Incapacitation. Okay, we do decommission machines that are dangerous. If an animal is dangerous, say a dog bites a child, we might kill the dog, but we don't regard that as punishment. That's not a moral judgment of the dog. That's an administrative decision by the state. Now, in medieval times, we did in fact have animal trials. And I've got a paper that looks at that in terms of the relationship with robots today. But I don't think either of those really apply in moral terms. Incapacitation might, and that's again, we can take a dangerous machine out of circulation. We can ban certain types of substance or machines because they're too dangerous. We can impose limits on how fast a car can go, for example, because it's dangerous. But deterrence and rehabilitation might be more interesting, because deterrence is clearly one of the reasons why we punish corporations. When we punish corporations, and we can in some jurisdictions even criminally find a corporation guilty of murder, the reason we do so is partly to deter others. But that corporation operates as an economic entity where the losses, the punishments are being passed on to human decision makers. In terms of a machine, deterrence, you should not need to deter a computer or a computer program from committing a wrong. That should be a starting decision. You shouldn't be able to do something through a machine that you couldn't do yourself. But the most interesting, and the reason I touched on it, is really rehabilitation, that as AI systems become more prevalent, we might see a shift in the way we think about this, that we're not punishing machines. What we're doing is not punishing sins, the way some people think of wrongs in humans. We are debugging errors. So we are using this as a virtuous feedback loop. So again, back to cars, if an autonomous vehicle runs a red light, you don't fine it necessarily. You debug it. You look, okay, well, why did this happen? How can we prevent it ever happening again in a way that would be quite different from the reasons for punishing humans? So sorry, that's a long answer to a very good pair of questions, but this is an area that lots of people are still trying to work through. Thanks, Javier. Good to meet you.
Thank you. And the next question up, I believe, is to make life easier. In the chat box, you're referred to by rather anonymously by initials sometimes. So I'll just use that. I believe LN, I believe, was the next person who I'll ask our host to invite, please. Louise, thank you. Please do unmute yourself.
Oh, yeah. Yeah, just a question about, are we ultimately going to put individuals at a disadvantage here in a similar way to where you have a problem with piercing the corporate veil when it comes to corporations, that it's going to be the same if we were to give legal personality to AI in some way, that it's rather than improving matters, it will provide a further layer of smoke and mirrors. Very interesting talk, thank you.
Thanks. And sorry, just how do you pronounce your first name?
It's Lisha.
Lisha. So that's it's a great argument indeed. I agree with it. So I went through it reasonably quickly in the presentation, but my main concern is precisely that you could give legal personality to AI systems. I mean, every autonomous vehicle you could just make it a corporation. Limited liability, the consequence of that would be limitation of liability to the assets associated with that entity. Why would you do that when you don't need to? And the only consequence would be minimizing loss. If the concern is that autonomous vehicles crashing will impose bankrupting losses on companies, you can have an insurance regime, you can impose maxima, but given the uncertainty of the status of AI systems, adding that layer would merely have the consequence of insulating precisely traditional legal persons. Because at the moment, I suppose there are two kinds of arguments. One is that you would be insulating them from liability. Two, you would be creating the incentive that if you wanted to do something dubious, to push at the limits of legality or perhaps morality, you could do that through an AI system in a way that you couldn't as an individual or even as a corporation. Now, occasionally this is an argument made against corporations themselves, but as Lisha said, there are limited circumstances in which you can pierce the corporate veil. Some of the people who've argued in favor of legal personality for AI and even sort of rights for robots have argued you could have a similar regime, and it's true, you could create a similar regime, but since you don't, I would argue, need to create legal personality in the first place, then I tend to agree that at least at the moment, the costs would outweigh the benefits, so there's no reason to go down that path in the first place. I suppose one last point is just to highlight, and this is implicit in at least what Lisha and I are saying, that there is a tendency for many of the norms here to be driven by extremely well-vested interests. And so it's striking that sort of regulation of AI around the world tends to be dominated by sort of the European Union, GDPR, limitations on automated processing, and sectoral interests in the United States. And I mean, I somewhat dismissively talked about Asimov's norms earlier. It's striking that it's in the last 6 or so years, we've had lots of technology companies, among others, come out and advocate for ethical principles, frameworks, and so on, even regulation. And this is both an indication of their power, but also their wariness that some kind of regulation might be coming in a form that they're not quite so enthusiastic about. So lots of vested interests here. And again, a reason to be wary of insulating traditional legal persons from liability.
Thank you. And we'll move to the next questioner who on my list, here we are. Katerina, please, over to you.
Good afternoon. I'm very sorry. My connection is so bad, but I tried to ask my question. There was, in case of when AI, or if AI can self-destroy itself after a crime, I don't know, accident or any other damaging situation, could it be, or who will be, or would be, or could bear the responsibility for that damage or crime? And is there any succession applicable for that? Thank you.
Thanks, Katerina. That's a great question. And forget asking me the legal question. Go and option it for movie rights. That's the plot of a very fine movie. So it's a good question, and I'd go even further. It's the self-destruction is one thing, but just attribution in the first place is going to be a problem. Again, we often conceptualize this as the kind of humanoid robot. This is really what Isaac Asimov is to blame for. We conceptualize this through the android fallacy as humanoid robots going around doing things to humans, when it's much more likely that AI will be disembodied, spread through the system, operating in the cloud, or it will be sort of swarms of drones engaging in activity, and it's impossible to trace it back to any actor. If you look at the way in which cybersecurity operates at the moment, We had the biggest hack in Singapore's history a couple of years back, where 1/3 of the population's personal data, the medical history of the Prime Minister, was stolen. And there's no, well, there are suspicions, but there's no formal attribution of that back to any actor. So there'll be plenty of activity where there is, it's very hard to find anyone at fault. So how do you approach this? Well, if you did have legal personality, I suppose it's conceivable that there could be succession. One of the reasons why we justify having legal personality for corporations is precisely for permanence, so that you can have things that last a long time. There would be ways of doing succession. But more interesting perhaps is sort of what happens if you can't attribute activity to anyone, or if there is a computer program, it's dissolved itself, or the machine has blown itself up. Well, in those circumstances, if you can go back through product liability, you can either identify a producer or a supplier, and under European Union laws and British laws, you can go after that entity, provided you can identify it as a product. This is an entirely separate set of challenges, which is that it's kind of astonishing that it's not clear whether computer programs are products or not. Most product liability affects products, and that's pretty easy to understand, but it affects products and electricity. But does it include programs? Does it include software? Astonishingly, that question is not clearly answered in most major jurisdictions. So the easy way to do it is if you can identify a producer or an owner or a user. If none of these can be identified, then a fallback regime might be that you could have mandatory insurance that covers everyone. And actually in the book length project, my background is mainly public international law. One of the things I'm advocating for is the creation of some kind of entity that would ensure that all states at least maintain due diligence in terms of preventing the production of uncontrollable or uncontainable AI systems, and that they maintain some level of traceability, so that hopefully the situation shouldn't arise. But the reality is it already does. We already have computer viruses that run wild around the world. It's not possible to attribute that back to anyone, and it creates all sorts of harm. And so we have a classic collective action problem that I would argue can only be addressed by recognizing the limitations of territorially bounded states and having some kind of minimal global regulation.
Thank you. And perhaps if I can just abuse the positions, just to interject before the next questioner, who I know is just about to appear on screen, Anuj Puri, but I'll just butt in. Is there much difference between what you were just saying, Simon, and should we say some of the regulatory regimes that have been put in place in completely other areas where there may otherwise be, should we say liability gaps? I'm thinking of areas in one of my own areas, in the law of the sea, for example, where you have these general liability conventions that everyone involved in an activity ultimately has got to pay into to ensure that there is at least some fund somewhere which can pay out if any unattributable damage arises from an entire category of activity.
So yes, that's a great comparison. So there are kind of two extremes in the international level. One is the sort of general liability, or domestically you have, and I think we'll see this at least in transportation, that to use cars, whether you're driving them or not, you've got to pay something into a general insurance regime that covers accidents. New Zealand has gone further in that all personal accidents are covered through a mandatory insurance regime. And you could imagine doing that globally. Mm-hmm. An alternative is the Space Liability Convention, where under space liability, you are absolutely liable for things launched from your territory that land. There are other comparisons, and in the book length project, I actually draw a comparison with the regime of nuclear energy. Which is an interesting comparison because it's also an area where back in the 40s and 50s, there was a serious discussion. This technology has the capacity for enormous good and enormous harm. How do we get the benefits while mitigating the risks? And the benefits were, and this is what the International Atomic Energy Agency was founded to create, the benefits were the spread of technology, nuclear technology through energy production, medicine, and so on, agriculture. and trying to limit in what ultimately became the Non-Proliferation Treaty. And so in the area of lethal autonomous weapons, which is a kind of extreme case of possible harm, you've seen arguments for a moratorium on lethal autonomous weapons that are not subject to quote unquote meaningful human control. The problem is that the states with the greatest capacity presently have the least interest in limiting their own abilities in these areas. But no, I think it's a great comparison with the law of the sea, Malcolm.
Yeah, thank you. Let's return to the list, and we've Anuj is waiting to pose your question. So please do unmute yourself and take the floor.
Thank you so much. Thank you for that great talk. I was thinking about it from a comparison between moral and computational autonomy perspective. Moral justifications often form the bedrock of legal defenses. Now, AI can be considered autonomous in a computational sense, but it would be a tougher case to make out that it's autonomous in a moral sense, that it has moral intentionality or it understands the moral repercussions of its acts. Now, in that sense, are we committing a mistake of categories, or are we going down two different tracks? That if we consider AI to be morally autonomous, then the conferring of legal personhood is on natural person's lines. But if we consider them to be computationally autonomous, then the conferring of legal personhood is on like the way we treat corporations as legal persons. Thank you.
Right. So another great question. So I'll blame Kant for this, because if you go back through the history of the word autonomy, it goes back to the ancient Greeks. And for more than 1,000 years, the word autonomy basically meant autonomos, meant able to form its own laws. And so it was used almost exclusively in a political sense to refer to politically autonomous entities. And it's only by Kant you get this idea of the self-regulating human. And yeah, I would agree that I don't think there are any serious arguments yet. So some people would disagree with this, but most would not argue that artificial intelligence systems are yet morally moral persons. Although some people, I think they're fringe discourse, some people argue that corporations are moral persons. I disagree with that, I think broadly for, I suspect, the reasons you do. And so again, I'd come back not to this is really asking, what you're asking is a different way of framing what I referred to as the instrumental and inherent arguments for personality. So instrumentally, if it's a matter of how do we allocate loss, do we need to allocate that to a corporation? If so, personality might be a vehicle. I don't think that's necessary. But the inherent argument is, if eventually we do get to the point where there is an ethically, morally autonomous system with something resembling consciousness that appears to be of equivalent moral worth to us, how would we deny that? Well, the problem is we're already able to deny it to animals. So we have chimpanzees, we have sophisticated animals like dolphins that have some kind of moral sensibility. And indeed, some people go further, and you can make this gets into controversial terrain, but there's an argument that a chimpanzee has much greater moral sensibility and even arguably moral worth than a person who's in a coma. But most legal systems would not therefore say that the chimpanzee has more rights than the person in a coma. How do we maintain this distinction? Ultimately, it comes down to a kind of speciesism. And that's one argument that might end up applying to AI systems as well. Why don't we let them own their products? Why don't we give them moral rights for the creations that they produce? Well, because we humans, we're the ones that write the laws and enforce them. And that might be where we end up having to draw the line.
Thank you. And I think next up is going to be, I have the initials here, OL, I think we've invited. Ah, yes, here we are. Please do take the floor. Please do unmute yourself. And if you can, unmute the video.
There should be a word for the opposite of unmute. So turn on your video if you can, or Conquer.
Something like that, yes.
Okay, I'm sorry. Can you hear me now?
We can hear you. Please just, I believe you have two questions. So if you would like to ask them jointly together. Yeah. Our link, that would be helpful. Thank you.
I actually lost you. That's why I didn't pick when you asked me to unmute. So I'm sorry about that. want to register my, thanks to Simon Chesterman for the wonderful lecture. It's an area of interest for me. And my concern actually to express is what I consider a little bit confusion in the application of the concept of legal person being shared by AI, being shared by other robots and other entities in the legal world, and yet denied of some relevant beings like fetus. So I ask the question, would granting of legal right to AI, simple mechanism or device formulated by human beings, the natural person, not be an absolute open door to revolution, especially to the foundation of legal personality?
Okay. So great question. So you drew the comparison with legal rights, I think, of fetuses and other sort of marginal cases. I mean, I glossed over this in the presentation, but on the margins of humanity, it is actually quite problematic. So we tend to think that natural persons have rights as legal persons as of right, that you don't need, there you are, Concord, that you don't need to, all you need to prove is that it's a human. And that's usually pretty clear, but there are marginal cases, both at the beginning and the end of life. The beginning of life, where precisely it begins, what happens to neonates, what's going to happen as scientists have now started growing brain cells in petri dishes, at what point does something become sort of human, what happens with chimeras and so on. There are marginal cases there. And also at death. And indeed, the first article I ever published in the International Comparative Law Quarterly was on euthanasia and the really problematic end-of-life decisions. But so by creating a new category, I think there is a danger that it would, if you had an imprecise category, and this is the problem at the moment, we don't have a precise category. The reason we give corporations personality is we see there is an economic advantage in doing so, and we set up forms and procedures that humans have to go through in order to establish a corporation. Other non-human entities that have been given degrees of personality have all been through human actions. It's humans that are the ones that, as of right, are entitled to this form of legal personality. And I think there would be a danger in just establishing a category that any entity that could then lay claim to. I'm not sure I would go as far as the revolution, but I do think there is a danger of a floodgates type argument that once you establish the criteria that if they were satisfied, then that entity could claim personality. It goes back to Lisha's question about whether you would then have incentives for various activities to be channeled through that entity precisely to limit liability. Maybe one last point on personality, and this goes back to public international law, that international law has had similar challenges in terms of international organizations. So for example, the UN was established back in 1945, and it was unclear for several years whether the UN had sufficient legal personality to take action when it was wrong. And it took the death of a Swedish negotiator, Count Folke Bernadotte, to lead to the reparations case and a finding by the International Court of Justice that international organizations could have some degree of personality, although how much legal personality they have is subject to negotiation. So that's more a thread that if people are really interested in these legal personality questions, they could follow. But on Okonkwo's question, yeah, I think there is a danger with creating these imprecise categories that could ultimately undermine our own claim to having a monopoly within the legal system.
Thank you.
Thank you.
And we can now move on to our next questioner. Yes, just appeared on screen. Gar-Ing, please do unmute yourself and take the floor.
Good afternoon. Thank you so much for the very interesting presentation there. I was just thinking, you were talking about growing of brains in petri dishes and artificial, and I was just thinking back to Elon Musk and his recent experiment with microchips in a monkey or an ape's brain and the controlling of the screen there. So what would be the legal implications of this for artificial intelligence and the distinction with life there and legal personality? Thank you.
Great question. And so I think this might be a footnote in the article, but it's a wonderful question. So the short answer is, if we're talking about augmented humans, then legal personality goes with the human. And so if for example, projecting forward, I mean, it is kind of shocking that these phones, the iPhone was only invented only released in 2007, and now it's become really an extension of our brain. So I can remember maybe 5 phone numbers. Before 2007, or back in the 1990s, I knew dozens and dozens of telephone numbers. So we use these as an extension of ourselves. And I think it's entirely realistic, despite the failure of Google Glass, that we will, at some point in the very near future, have at least wearable devices, and then the transition from wearable to implanted is very easy to see. And if you want the sort of dystopian version of that, go watch Black Mirror episodes of your choice. So again, the short answer is, if we have an existing human who has augmented capacities or has some sort of implant, then they remain a human. But the interesting sort of, I suppose, 2 marginal cases would arise. One is the sort of non-human hybrid, the sort of growing brain cells in petri dishes, and that would be similar to debates about stem cells. But in some ways, the interesting question that this raises with the implants is what standard you would hold such a person to. So, for example, there is a lively debate going on in Singapore right now about autonomous vehicles and what standard they should be held to, because ultimately autonomous vehicles should be much safer than humans. And if you artificially limit them to human level standards, that won't be realizing their full potential. And you could imagine a scenario where augmented humans, if they had improved vision, improved reaction time, would be held to that higher standard. And so that would be an interesting set of questions. I mean, it gets more and more speculative the further we go, but given the speed with which mobile phones came to dominate our consciousness and our ability to keep track of information and our engagement with the world, I don't think it's crazy to think that 20, 30 years from now, the relationship with devices is going to be even more intimate with legal consequences that would follow. So great question.
Thank you. Yes, and maybe if I just add to that, it's just reflecting the same point. As I understand it, there's a lot of work already being done within military forces around the world to, have AI enhanced, should we say, human capacity in terms of increasing the endurance of military, as well as their ability, their vision, etc., and physical capacity as well, which is, just doubtless an extension, an example of the very point that you're making and the questioner is making.
Well, and I can't resist responding. I think that's an excellent point. And indeed, in separate work, which we could talk about, the reasons why we are wary of lethal autonomous weapons are quite different from the reasons we're wary of autonomous vehicles. Autonomous vehicles, as long as they can be safe and not crash like the one that did in Houston, then I think most people, trolley problems aside, we could debate that if people are keen. But basically, autonomous vehicles, transportation, medical care, those are areas in which optimization is clearly going to be beneficial, and it's just a matter of solving the problem. Lethal autonomous weapons, do we want machines, for example, to be replacing soldiers in the battlefield? Now, Terminator notwithstanding, there are good arguments to believe that lethal autonomous weapons would be safer, more reliable, more disciplined than human soldiers. Many war crimes occur because soldiers are fatigued or angry or racist or whatever. And these are things that machines could be designed to avoid. But most of us tend to think viscerally about our moral intuition is to be wary of handing over life and death decisions to machines. Because even if the machine was making better decisions, because we tend to think, at least most of us, that such moral decisions should be grappled with by a human who should then be held accountable for those decisions. So sorry, that's a bit of a tangent, but prompted by your very interesting observation, Malcolm.
Thank you. Well, I won't hog it, although I'd love to. We've got Felix is on the line, so I'll hand the floor to Felix. Felix, please.
Hi, thank you very much, Simon. You've touched about enforcement a bit and the speciesism, as you said. I wanted to ask whether you think we should or will have a kind of machine-to-machine dispute resolution mechanism, given the fact that we already currently struggle to understand certain decision-making processes that are taking place in deep learning or machine learning algorithms.
That's great. So the last chapter in the book, I'm just going to put a shameless plug in the chat for the book, which is not yet on sale, is precisely on what role AI could play in regulating itself. So the maybe two answers to this. The first is just understanding what machines are doing. There is a whole discipline of explainable AI, and AI systems actually, it turns out, are pretty good at trying to explain what other AI systems are doing. In terms of dispute resolution, again, though, it goes back to the question of why we want dispute resolution, what disputes we're trying to resolve, what we're trying to achieve. And if it's a matter of disciplining the machine, then hopefully the machine, the system itself should be self-disciplining. As if you can program in the correct parameters, it shouldn't require an external actor punishing it. So again, the comparison maybe with automobiles is illustrative. The reason we have traffic laws is that the official reason we have traffic laws is to maintain safety and order on the roads. The real reason we have traffic laws is people need to be taught to behave. And so if you could internalize those norms into machines, then it shouldn't be necessary to have a dispute resolution. The reality in the medium term, however, is we're going to have more and more sort of disputes where there's no human actively involved. And so that case I mentioned in Singapore, the B2C2 and Coin, these two trading algorithms, so they had a dispute, and it took like years to resolve a dispute, which took seconds to arise. In terms of the machines themselves, where I think we might be going is, much as there's a debate now about privacy by design, I float this idea, and a few other people have written about it, of regulation by design, that we could build in not laws ex post facto, so we try and educate people and then we punish them if they misbehave. But if you could build it into a machine, if you could design it in, then in theory at least, you should avoid many of the problems that would otherwise arise. Now, there are huge limitations on regulation through AI, not least the fact that by handing over many of those powers, we're giving up much of our legal control. But I think at least some aspects of the dispute resolution should be taken away by designing it into the machines in the first place.
Okay, well, thank you. And just listening to that question, we can immediately see a whole new other world opening up here around us as the implications of this subject get larger and larger. Next up is Robert. Robert, please.
Good morning. Sorry, I rolled out of bed here on the West Coast of the United States, but my question had to do with dispute resolution also, and whether you thought that legal personality would be a prerequisite perhaps to having an artificial intelligence act as an arbitrator. I mean, right now we see a little bit of online dispute resolution that doesn't involve a human being, but probably not to big disputes that would normally go, say, to international commercial arbitration.
So thanks, Robert. Great question. And so you're right. So you probably know this, but just for the benefit of others, there's lots of online dispute resolution. So eBay famously resolves at least 60 million disputes every year without any human intervention. And I haven't checked this in a while, but I believe eBay's dispute resolution system is set up such that if it's a dispute below $250, basically it's impossible to get a human lawyer involved unless you go outside and have judicial review. There are interesting experiments, most prominently in China, in terms of truly resolving disputes through AI systems. And at the moment, it goes back to the sort of hybrid human interaction you have in various courts in China. There's both a deviation warning system, and there's a sort of prompt as to the appropriate sentence that a sort of machine learning algorithm has looked at all the comparable cases and fed them in and said, prompted up the likely outcome. Now, many of us are wary of this for a couple of reasons. One is that it basically shifts discretion not really onto the machine, but onto the coder. So how you code this information will have an enormous impact on how a dispute gets resolved. The second reason why I'm wary of going too far, and your example of international commercial arbitration is a good one, is that if there was an easy answer to most legal questions, courts would cease operating and lawyers would go out of business. The vast majority of civil litigation in particular is corporations suing one another and occasionally suing individuals and vice versa. Now, the amount of money that's at stake, the amount of high-powered individuals who are involved, if there were a clear answer attributable to the law, then they would settle out of court because they would both work out what the answer was. So if these QCs and so on can't predict the correct answer, why would we think we could code it into a machine? And the problem is not that the machines are too dumb or the people are too dumb. The problem is the open textured nature of law. That law is not a closed system and language is not a closed system. And this is why, and again, the book deals with this in a bit more detail, and there's a whole literature on this, that you can't simply code. Well, it is possible to do computational law, but it's very, very limited. And even and so the famous examples like, okay, say to pick a Lon Fuller's example, let's say there's a law saying no vehicles in the park. Okay, it's pretty clear you can't drive your car into the park. Can you ride a bicycle into the park? Can a bus go into the park? What about a pram? What about a statue of a World War II tank? And intuitively, most humans would agree on some of these being acceptable, some not being acceptable, but it's not clear from the language. And that's a really easy case. Traffic law might seem to be an easy case. I mean, if you go beyond a certain speed in a speed limit delimited zone, then you get a fine. But even that, there are requirements to act reasonably, there are emergency situations. It is incredibly hard to bound these systems in a way that machines can interpret properly. Compare that with like two alternative scenarios. One where the answer is clear and one where we don't care what the reasons are. On answers being clear, if it's a matter of is something spam or not spam, or is a trader even engaging in fraud or not fraud, there you can generally sort of train a machine to get the correct answer, but it's a yes-no question. Those sort of binaries are much easier to attribute. Or you have situations which we don't really care what the answer is. And here the comparison I draw is, the distinction I draw is between medical decisions and legal decisions. So in medicine, there are all sorts of decisions where we actually don't care what the reasons are. So there are various treatments in medicine, various pharmaceuticals that work. And why do they work? We don't really care. But we show that they work through statistical trials, double-blind randomized controlled trials. And as long as they get the right results with a minimum number of adverse side effects, we're happy to proceed, even if we don't understand at a molecular level why they work. Just maybe the easiest example, somewhat controversial one, electroconvulsive therapy, for example, is very useful in treating some forms of depression. Why? We've got no idea. It seems kind of barbaric, you're shocking someone, but we don't really know why it works. It does. Jump back to law. If, to use, Robert, your example of international commercial arbitration, if the parties fed all the information into the AI system and it said, well, in a randomized trial of 95 times out of 100, the result is your side wins, the other side loses, we would be very unhappy because we want reasons. And indeed, the way in which we tend to think about law is intimately associated with reasons. We want reasons, and indeed the failure to give reasons can be a reason for challenging certain administrative decisions. So, long way of saying, yeah, I'm not holding my breath for robot judges to take over on litigation, but dispute settlement, mediation even, robots and AI systems can be quite good at encouraging us to realize that the efficient way to resolve a dispute might be the fastest one.
Thank you.
Thank you. And we'll now move on to SP, Stephen Parker, I believe, if he's there. Please do unmute yourself. You need to unmute yourself, Stephen.
We still can't hear you, Stephen, but I must just say this is really nice to actually see questioners rather than just getting disembodied chats.
Yeah. Oh, there we are. Sorry, we still cannot hear you. Can you unmute yourself? Cannot hear?
Hi, can you hear me now?
Yes, absolutely. Perfect.
Sorry. I've got a problem with the system.
Okay, while you're looking at the system, I can see your question about anonymous AI. So let me just answer that while you're getting it set up. And I would...
Should I just read out the question for everybody else so that I can see?
Yes, please. I'm having trouble technically here.
Okay. The question is that you were saying that you suspect that the majority of AI systems will in fact be anonymous, particularly in cyberspace. Should anonymous AI be banned on the basis that it cannot be held accountable?
Yeah. Okay, we can't hear you again, but I at least got that part of the question. So let me have a stab at answering it and then come back if you wish, Stephen. So I mean, I mentioned that there are now dozens and dozens of principles, guides, frameworks, countless efforts by Google, IBM, international consortia like the Asimov AI principles. The Pope endorsed one set of principles back in 2020, and they all reduced down to, I think it's about 6 principles, most of which are completely unnecessary. So things like data protection or privacy, I mean, that's already a legal regime. Accountability, that's a way of saying that the law should apply. The two, safety, I mean, you shouldn't be able to sort of breach norms. You should be, of course they should be safe. The two that are kind of interesting are human control and transparency or explainability or traceability. So human control we've kind of been talking about, but this is a good question about transparency, explainability, or as I'll focus on in response to your question, traceability. Because unless you can identify where an AI system came from, who it's attributable to, then you do have a real problem. And so I do think, I wouldn't frame it as anonymization, I'd say it as traceability, or not letting the maker be anonymous. The problem is, it goes back to the global phenomenon that to do this, doing it in individual jurisdictions is insufficient because computers don't care about boundaries. I mean, I don't actually know where you are, Stephen. You could be anywhere on the planet, provided you're sort of hooked into a system. So some people draw the comparison with the way in which the internet is administered. And so there is a body, ICANN, which was a not-for-profit incorporated in the state of California. Now it's a multi-stakeholder system. I tend to think we want something a bit more robust than that, because at the moment, all that ICANN really resolves is naming disputes. But if you want something with a bit more teeth, I'm actually proposing something that would be on a comparable basis to the International Atomic Energy Agency. Imaginatively, I'm calling it the International Artificial Intelligence Agency, just as a thought experiment, to try and address precisely 2 questions. One is human control. So it should be a violation of the law to produce an AI system that is uncontrollable or uncontainable. And traceability, that it should be against the law and then implemented domestically to produce AI systems that can't be contained or that can't be traced back to traditional legal persons. And so the problem is we have lots of examples of viruses that get released into the internet that download onto our machines, and it's sometimes hard, if not impossible, to trace them back. And so we've established a regime that cybersecurity around the world, you can prosecute the people that produce those viruses if you can find them. So I would separate then the question, Okay, there's the practical question, how do you find them? And that might be extremely difficult. But if you do, you can try and punish them. But the people you're punishing are the individuals who wrote the code or who set in motion the series of consequences that led to the virus going viral.
Thank you. I'll move on. There is one other question which the person has written in who isn't, but say they're not able to answer. They had to leave, but hope that I would ask it on their behalf. So I will. In doing so, I note we have about another 8 people wanting to ask questions, which is fantastic. But I'm also conscious of the time, and we do hope to finish by no later than, I should say, 10 o'clock in Singapore to bring it home to the time there. So hopefully we'll be able to move fairly promptly through the existing list of questions. And so I'll finish the questioning list at this point, unless we have any additional time. But
you are very politely saying my answers have been too long. I will be brief.
No, it's all been absolutely fascinating. The question I'd like to pose is that of PS on our chat list, P. Sean Morris, who says that AI justifications tend to drift towards private rights as such and exclude arguments relating to public rights, constitutional, civil, human rights. And therefore, a simple question, should AI enjoy, for example, human rights along with public rights, I suppose?
Right, so there's a robust debate on this. David Gunkel, among others, I think Gunkel has plotted a sort of graph showing the division among theorists between those who think that there are basically 2 axes. Could AI have rights and should AI have rights? And I'm very much in the could but should not. And that's very much from a legal perspective. The moral question we were touching on earlier with Anuj, but legally, yeah, I mean, you can give rights to anything in theory. And by that, I mean things like the legal personality rights of corporations, of natural features, and so on. But should we? And I don't think there's a call for it. And the easy sort of baseline is self-preservation, that if we give other things rights, they might use it against us. But I actually don't think the argument's been made out that as of right, that the reasons why we even grapple with giving chimpanzees rights, I don't think machines are yet at that point. There will, however, be a set of problems that arise as sort of social robots become more of a phenomenon. So it's, for example, at the moment, it is illegal for me to set fire to a chimpanzee, quite rightly. It's not illegal for me to set fire to my computer. But as personal devices, as robots become more and more human, as they provide care, as they sort of look more human, as there's a whole obscure literature on sex robots and so on, as things that look human become mistreated, there will be important norms that are necessary to either protect them or at least protect our own moral sensibility. But the short answer at the moment, no human rights for robots from me.
Okay, thank you. Well, let's move on. The next is on the mysterious listing I have is KM, who hopefully Liam's able to connect for us. Don't know if we are able to get KM. No, I don't think so. Why don't we try to then move on to DD is next on my list. And if there's time, I'll read out the question later. Yeah, please do take the floor.
Hi.
Danielle, all the way from Singapore.
I'm in Brazil, but I'm researching with Singapore. My question is about the challenges with distributed technologies. If we can put this in a norm form, pretty much procedurally speaking. Please, can you elaborate on this point, please?
Yeah, so you're right. This is a great problem, but it's an existing problem. So I've got an iPhone. So Apple company makes it, but it's made of components from around the world. We have lots of things that people assemble, and when part of it fails, there's a whole argument about who's responsible. But these are resolvable through traditional sort of legal questions. A key question, though, is not just the composition of programs, but the distribution and what happens if they evolve. So, for example, AI systems that are distributed around through a system, you can easily imagine a program that starts modifying itself in a manner that gets beyond the capacity of the original creator. Now, we have this to some extent in AI systems that are producing intellectual property. So we have systems that can produce music, produce art in a manner that the individual programmer might not have been able to. So who do we attribute that right to, or who do we attribute that wrong to? At the moment, the right would go to no one. AI systems can't own copyright. The wrong, however, would go back to the person who set it in motion. But for the most part, yeah, I mean, existing product liability, at least on the civil liability front, it's reasonably clear. Criminal liability would be much trickier. But as I was saying earlier, I think there's less call to criminally punish these systems as opposed to trying to debug them, for example. But good question.
Sorry, but my doubt is about algorithms that have the anonymity as default. For example, if we are thinking about blockchain, if we are talking about misleading activity or input of wrong data in a Bitcoin blockchain-based technology, we wouldn't be able to hold anyone responsible. So what would be the use of having this technical person if we couldn't actually do anything about it?
Okay, so well, if you're talking about artificial legal persons, I agree, we shouldn't create them. On blockchain, I mean, of course, blockchain is not really anonymous. Blockchain is pseudonymous, but it's traceable back through the distributed ledger technology. But the ability, I mean, there are all sorts of wrongs that go on in the world that are unpunished. I mean, if I go outside and my car's been damaged and someone scrawled, Chesterman, you don't know anything about AI, and there's no CCTV, it's just a wrong that goes unpunished. This will continue. But the fallback, if we want to guard against those difficult to compensate harms, while not unduly restricting technology, insurance is the way to go. And so if this becomes a real problem, then some kind of insurance policy will be necessary. And then the challenge is, well, how do you price that? But there are ways in which we could probably deal with that. But no, good question.
Thanks.
Thank you. And the next person I'd like to ask, sorry, a bit late getting the message out, is SK on my list, following through the order. I believe 2 questions has been posed by Shazia, so if I could ask you to combine them both briefly. As I say, I am conscious we've only 10 minutes left, but we do want to get through what we can. So please, over to you.
Hi, hello, I hope you can hear me.
Perfectly.
Oh, thank you very much. Thank you for an excellent talk. It's been absolutely instructive and very interesting indeed. So I'm a PhD student at Queen Mary. I'm currently studying fintech and whether or not current regulation in fintech is appropriate, or rather current regulation in financial markets is appropriate. So one of the things that I noted that you talked about before was explainability. So this is something that I'm thinking of. If we have explainability, then do we really need to have this legal personality? I think you kind of answered that after I asked the question. So just a bit more thoughts on that. And the other question I had is, I mean, in financial markets, one of the key things that we think about a lot is compensation. So tort law, I mean, of course you have fiduciary law, so that's about prevention, and criminal law is also about prevention. But obviously when a consumer buys a financial product and suffers loss, how do we go about providing restitution for them or compensation, and how might we go about doing that if we have robo-advisors advising on buying certain financial products. So just your thoughts on those two. Thank you very much indeed.
So more good questions. Just maybe going backwards on the robo-advisors and a whole section on high-frequency traders and the effort, and you probably know the May 2010 flash crash, where in 30 minutes, $1 trillion was wiped off the New York Stock Exchange, and in half an hour, most of it came back and no one knew what happened.
Yeah.
So one question is, yeah, who's providing the advice in terms of robo-advisors? And I recall there's an article on sort of how you need to frame very clear terms of use so that it's clear whether the individual is getting advice from the bank or whoever has produced the machine, the algorithm, or if they're doing it on their own cognizance. Because it's a bit like if a lawyer, if I write a textbook that provides various answers to a legal set of questions, that doesn't count as legal advice. If I provide an online Q&A, it's probably also not legal advice. But if I have a machine learning system that you feed in all your information, then it says, right, these are your legal rights. That looks a lot more like legal advice, but it might not be coming from a lawyer. And you have a similar situation in the financial sector with a regulated profession. One thing that London and Singapore have experimented with is sandboxes, so that you can experiment with some of these products while mitigating the harm. And that's probably the first step, is to try and reduce the likelihood of major harm. But otherwise, yeah, I mean, the loss lies where it falls. Hopefully you have only sophisticated investors that are engaging in really risky behavior, and then tough luck if they lose money. And then lastly and briefly, yeah, on explainability, the main argument for legal personality, the main instrumental legal argument for legal personality is if there's no one else you could sue. And if that were true, so if you couldn't attribute it back to anyone, if you couldn't explain what was going on, then maybe that would be an argument in favor of personality. But personally, I think that's more of an argument against that situation rising in the first place.
Yeah, that's what I thought. Yeah, lovely. Thank you very much.
Thanks, Shazia.
Thank you.
Okay, thank you very much. And I think we are now moving on to, is it SS on my list? Oh, no, sorry, B Davis, please, yes. And then SS. And we might take these two together because I think the questions are quite closely related, so you might be able to answer them both together. So please, could you unmute yourself, please?
Oh, hi there. Sorry, I'm having a little trouble with my video. Are you able to hear me?
Yes, we can hear you fine.
Sorry about that. No, sorry. It was actually more a commentary on Javier's question about viruses. We have an act from 2018 which discusses the liability of autonomous vehicles and introduces the concept of an insured person into the mix. And one of the requirements, obviously, is that the vehicles are kept up to date. And so this, to my mind, introduced this element of somebody, in Javier's example, somebody maliciously interfering with the machine, or in the case of an autonomous vehicle, failing to keep it updated, but introducing this concept in terms of AI, from an AI perspective, what we might call non-compos mentis condition of the machine, if you will. So I just thought that was an interesting take on a similar situation.
Well, thank you. And I think that's quite closely related to the next questioner. So I thought if we take those as well, and that's Santanu. Could you take the floor to unmute yourself? Thank you.
Sure, thank you. Thank you so much, Professor, for this very interesting talk. My question was about what are your thoughts on extending product liability and probably make certain modifications depending on whether we are talking about a failure or a damage which is of a civil or criminal nature. I think some of it you have already answered to questions on similar lines, but what are the major challenges do you think that it could pose?
Yeah, good question. So, I mean, with product liability, we're focused mainly on civil liability, compensation for loss or harm. And the challenge are the ones we were just talking about, attribution, and identifying precisely who is responsible. And there might potentially be some gaps, but at the moment, I mean, almost all machines. So this Tesla that has just crashed, there's going to be a product liability lawsuit coming out of that. Most autonomous machines, if we go back to that idea of robots interacting with the world, it's pretty clear they count as products. The harder one is actually when we move into distributed services. So if Siri causes you some emotional distress and no one can explain why, then that's going to be a much harder problem in terms of identifying it as a product. And back to, sorry, I think it was Ben, was it? B. Davies. Yeah, you have a separate criminal regime that I think is the case in England, certainly is the case now in Singapore, that you make it a crime to interfere with autonomous vehicles, for example. And indeed, this is one of the real challenges with AI, is not AI harming us, but people making it difficult for AI. I mean, if autonomous vehicles were on the road with only autonomous vehicles, it'd be much easier. The real problem for autonomous vehicles is interacting with humans.
Thank you. The next questioner is on my list is YW. Why-ming. I'm conscious that this is a question that could require a lecture in itself to give an answer to, but we'll ask the question and maybe just a quick flavour of a response in the dying moments. Please unmute yourself and over to you.
Luckily, I know where Wai-Ming works, so I can go and have a beer with him and discuss this in person if he likes.
I thought you might. Yes.
Thank you, Prof. It's an excellent lecture you have given. I think you may have actually answered one of my questions. Is about the Singapore AI framework. You mentioned the example relating to, how you want to set up the atomic agency, something similar to the AI agency to regulate some of this framework. But I see that this is actually a top-down approach from the Singapore government, and it's more like a framework, a guideline for the developer of the AI itself to ensure that they are more, it seems to me to have more a human feature than artificial intelligence, and to hold the developer accountable. Now, is this going to be the same kind of thinking that you would have in terms of your example of the so-called artificial agency, for the world, and whether we should have some form of homogeneous development in terms of a framework to regulate, because AI transcends the whole world. Prof.
Right. Okay. So I realize we've just hit time. So Malcolm, you and I get paid overtime from now, don't we?
Oh, absolutely.
So look, very brief. Okay, very briefly. One, buy the book. But no, two. I suppose the short answer is you need regulation at different times and at different levels. At different times, the Collingridge dilemma is this idea that at an early stage of innovation, you could regulate, but you don't know what to regulate. And the danger is you constrain innovation. So Singapore adopted a framework and explicitly in a penal code review said, we're not going to adopt criminal law reforms to address AI because that would just constrain innovation. If you regulate too late, the genie's out of the bottle and you can't put it back in. The alternative way of thinking about this is at different levels. And so the Singapore model framework, I think, is very useful, and it's easily Googled if people want to find it. But it's useful because it focuses on those two things that I also believe are the key: human control and transparency or explainability, rather than all these other things that are covered by existing laws. And the Singapore model is also aimed at encouraging industry best practices, and that will be part of what's going to happen. And you will have self-regulation of a kind in many areas. And I think that's necessary but not sufficient, because I do think there are some red lines we just need to draw. And the only entities capable of drawing those red lines are states with the capacity to impose hard regulation. And that's in areas like lethal autonomous weapons or the outsourcing of public authority machines. But yeah, apart from that, the model framework is, I think, one of the more interesting texts out there. But I declare an interest that I was involved in a small way in the framing of it.
Thanks, Prof.
Thank you. And if we could move now to what I fear was going to have to be the last of our questions, which is from AS. I know that another couple of people have indicated questions in the chat, but it was after I said we would have to close the list because we are right on 3, and I know people are having to leave. But we'll just take this as our final question, and then we'll wind up. So please, final question. If you could just unmute yourself, I'm afraid we can't hear you at the moment.
Just while this person's unmuting, I won't have time to answer it, but I do want to acknowledge Jacob Turner has written a very interesting question, and indeed has written a very interesting book, which some of you might want to refer to as well.
Right. Are we able, is AS able to ask the question? I can't see. I don't think so. If not, then in the final question, as you've mentioned it, you could, if Jacob Turner is there, we could quickly invite him to take the floor, so you could comment on that just before we close. Yeah, please do.
Professor Chesterman, thank you so much for your kind words and a fantastic talk. My question is with regards to the identification of AI for the purpose of determining which AI you're talking about when you ascribe it legal personality. So if we were to go down the route of giving AI legal personality, it seems to me that a key practical problem in this is identifying which AI we are talking about. Humans have a distinct physical form. It changes over time, but you can be fairly sure which human you're talking about at any given time. Likewise with companies, they are registered to a company's register, and one knows which company one is talking about in terms of rights and obligations. AI, and indeed all computer programs, function somewhat differently in that there can be many different iterations, which are sometimes described as the same program colloquially, but there may be differences between them. And this arises particularly with machine learning programs, which update themselves over time and may do so in lots of local iterations. For example, the facial recognition on everyone's iPhones operates entirely independently of the other iPhones in order to preserve privacy. So in those types of situations, I just wondered whether you had any views on how we would go about identifying which AI it is we're talking about if we were to ascribe it rights and obligations.
Excellent, excellent question. And I would say I'm actually against artificial intelligence having legal personality, at least at the moment. But you raise both an argument in favor of and against it. The argument in favor of it is because of its changeability, we will increasingly have AI systems that have gone beyond the control, design, capacity of their creators. And presumably some of these will keep evolving, and it'll be harder and harder to attribute things back to a human or a corporation. And that's one of the reasons why some people say, therefore, these entities should have legal personality so we can go after them. But as you point out, they will keep on changing or multiplying or dividing in ways that are very distinct from, as you said, both natural and juridical personality. The efforts to avoid this, there have been serious proposals that you can have a similar register. And indeed, a few cities have recently started having lists of the algorithms that operate. One of the arguments for transparency is to be clear. So, for example, high frequency trading, I think it's the Germans require the identification of the algorithm, but that only applies to a very limited category of computer software. So, yeah, as the software becomes more sophisticated, as becomes more organic in the sense of growing through experimentation rather than design, these questions will become even harder. But if I may, I would say it underlines my certainty of my original conclusion, which is that we shouldn't be doing this in the first place if we can at all avoid it.
Well, thank you very much for that answer. And perhaps with those words, something we should avoid doing, shouldn't be doing if we can possibly avoid it, is carry on any longer, because we've trespassed on everyone's time very, very considerably. I have to say, there are very many pleasures of chairing one of the ICLQ annual lectures, and of course one of the greatest is when I'm able to turn around to everyone present at the end and say, I really have to close questions now, but if you would like to carry on asking the questions of those who have not been able to do so, we can carry on to discuss all this over a drink in a room just down the corridor. That is of course one thing I'm not able to do today, but I am able to, on behalf of everyone, thank you, Simon, for the time you've taken, not only to give the lecture, but for the answering in such an authoritative fashion, such a diverse range of questions. You must have felt quite sort of overwhelmed by the range of questions and perspectives, but I think it just underlies the importance and interest of the topic. It strikes me that two things struck me here, that on the one hand, you've reminded us that personality, which is something which we tend to see as in absolute terms, is very much something that exists on a sliding scale, and quite how that calibrates depends so much on whether we enter into that scale from the perspective of rights or obligations, and that there is much that lies in between. But also the absolutely fundamental point, using language that you were using just towards the end, really, is, I suppose, to me, the simple question, nothing here is simple, just becomes, at what point does a createe break the chain that links them to their creator? Because that is, it seems to me that is the underlying tension that we are seeing here all the time. And I think, you clearly want to place a restraining hand on that, whereas others perhaps are more liberal in the point where they would sever that connection. But this is clearly an important debate that's going to carry on in many ways. And I think we've been privileged to have the benefit of your talking to us in the course of this lecture, and of course your article and your book that we'll all be looking forward to. So thank you very much indeed for being with us here today.
Well, thank you so much, Malcolm. Thank you to everyone for the excellent questions and your attention, and thanks to the BICL and the ICLQ for a wonderful event. I really enjoyed it myself and learned a lot. Thank you.